Provisional patent applications. What are they and how do they work? Well, a provisional patent application carries out a very important role. It establishes an international filing date for your idea. Patent attorneys call that a priority date. The international filing date means that from the day the provisional patent application is filed, you can claim that date, not just in Australia, but in any other country down the track, as the date at which you're laying stake to the idea that you're claiming the invention is yours. So a provisional patent application lasts 12 months. And during that 12 months, you can do a number of things. You can carry out a patent search, and you can modify your specification to get it ready for the next stage. So let's have a look at each of these three aspects. Firstly, to carry out a patent search, why would you do that? Well, patent searches are used to have a look to see whether an idea is new. The most comprehensive patent search you can get carried out at an affordable price is that done by IP Australia, the Australian Patent Office. The international type search service IP Australia offers is one that takes about 8 weeks and, taking into account attorney fees, costs a little over $3,000. Now, the catch with an international type search is that it needs to be carried out on the basis of a filed provisional patent application. That is, you can't just request IP Australia carry out a search without having first filed the actual provisional patent application with IP Australia. So we've filed our provisional application here. We've requested an international type search to have a look to get IP Australia's view on whether the patent application is novel, which is one of the key requirements in patentability. And coming up towards the 12-month term of the provisional patent application, we can then modify the original document so that the application that's filed at the 12-month point not only takes into account the original disclosure, but also takes into account any other developments you've made to the idea throughout this period of time. Now, those developments are incorporated into a new specification, effectively a modified version of the original specification, and that is filed at the 12-month point in either one of two types of documents. It could be filed in a PCT international application, which is an international patent application that reserves your right to file in a whole range of countries for another 18 months, or the modified patent specification could be filed in a direct convention application. A convention application is a type of patent that is linked to your original provisional patent application via the Paris Treaty. The Paris Treaty allows foreign patent applications filed within 12 months of an Australian patent application to claim back to the original filing date. So at the 12-month point, they're your two main options. Of course, in terms of filing in Australia, you've got some options there too. So you could file a standard Australian patent application or an innovation patent application. They're the two types of Australian patent applications you can file, and you can find out more about those patent applications in our other video blogs. Well, thanks for listening into my discussion about provisional patent applications. Of course, if you have any questions, feel free to contact myself or the team.